Thank you all for joining me. As you know, I'm Shanna Welsh-Levin with Cal Realty Law, and the topic today is landlords need to know the new laws for 2026. Interestingly, this year is not the most exciting year for new laws, so I'm also going to review some of what we learned in 2025 that was new. Right. Already went through the housekeeping. So let's see. New law number 1. As of January 1st, 2026, we have balcony inspections that are due. So if you have a property that is 3 or more units, the law now requires that you have the balconies inspected for safety. The other requirement for balcony inspections is it's not just balconies, it's balconies, decks, stairways, and other structures that extend beyond the exterior walls of the building, which are at least 6 feet above the ground level and supported in whole or in part by wood or wood-based products. These are called elevated elements. So if you have a property with 3 or more units that has these elevated elements, you are required by the beginning of this month. So in the past, you are required to have had an inspection, and then you have to have a re-inspection every 6 years thereafter. And you have to hold on to a copy of that and provide it upon request to anyone who lives there or to an inspector or the city. Also note that when these inspectors are performing their duties, they have to disclose unsafe conditions to the city or to the government. They are doing that and causing code violation notices to go out. In the city of San Diego, we get those civil penalty notice and orders. So we're seeing a bunch of those relating to unsafe balconies. The new law, because the balcony inspection law was from a year ago or more, the new law for 2026 is that if the building owner performs the inspection or has someone perform the inspection for them and confirms the presence of asbestos-containing materials during the inspection process, they have 9 months to complete the necessary abatement of those asbestos-containing materials, and then 3 months after completion of the remediation of the asbestos-containing materials to complete their initial balcony inspection. So I guess what happens is if you go to have the inspection and they find asbestos, they can't complete the inspection, and therefore you have a certain amount of time to delay the inspection while you remediate or abate the asbestos-containing materials. You have to retain those records that confirm the presence of those materials and the abatement of the materials for 3 years after completion of the inspection. I would recommend keeping them as long as you own the building. And then for HOAs, the new law also adds to the standard package of disclosures that HOAs are required to make that they also have to provide the most recent balcony inspection report. It mandates that the HOA will make that available, and they have to have a summary page. So the summary page has to indicate, among other things, which balconies are identified as posing an immediate safety threat. So the interesting example that we have that has come up recently in our eviction practice is that when you find out that your balcony needs to be replaced, and you go to do that work, your contractor is likely not going to be willing to remove a balcony or remove a staircase while tenants are in place. And in many cases, you can't have the tenants in place while things like that are removed. So we are having to do evictions based on a substantial remodel. And those can get a little bit complicated because from the tenant's perspective, the balcony is still there, the stairs are still there, the property is still habitable. It's this substantial remodel that requires the landlord to get permits. In the city of San Diego, you have to post the application first and then get the permits, and then you can issue your 60-day notice to terminate the tenancy. There's a lot of compliance issues with these. And so we are helping landlords to make sure that they're compliant. And if the tenants won't move out voluntarily, we may have to do an eviction. We have had to do evictions on these. The other thing to keep in mind is that you have to give the tenant the right to return to the property after the remodel is completed. So after the balcony has been repaired or the stairs have been repaired. So keep those things in mind. The next new law is an interesting one. Stoves and refrigerators are now required with some exceptions. So it was always my understanding that if you lease a property and there's a stove there or there's a refrigerator there, it has to work because your lease included it. You know, it was apparent that it was there when the tenant took occupancy, and many leases are drafted to state that these things are included. But, you know, there are places that are rented unfurnished. And if your definition of unfurnished is that it does not have a stove or a refrigerator, then the landlord must either provide the stove or refrigerator in good working order, or they have to enter into a written agreement in which the tenants have the option to bring their own appliances. So if you're going to enter into a written agreement, there are statutory requirements of the language, the statement that has to be in your lease. So the mutual agreement must state that under state law, the landlord is required to provide a refrigerator in good working order in your unit, but then you could have a check the box. It says substantially the following format. So by checking the box, you acknowledge that you have asked to bring your own refrigerator and that you are responsible for keeping the refrigerator in working order. The lease also must provide that the tenant may, within 30 days written notice, inform the landlord that they no longer wish to keep their own refrigerator in the unit. And at the end of the 30-day notice period, the landlord shall be required to install a refrigerator in good working order in the unit, or replace the word refrigerator with stove. Same kind of language would have to be in your lease. The exemptions to this law include a rental property that provides permanent supportive housing, a single room occupancy type of property where they have shared bathrooms and shared kitchen facilities, a residential hotel, or a housing facility that offers shared kitchen spaces. Okay, our next new law has to do with security deposits. And I'm going to not only tell you what the new law is for 2026, but there were some very important changes that took place in 2025, some of them in the middle of the year. So I'm counting those as new laws today as well. So first and foremost, the new law with regard to security deposits is pretty simple. It states that the landlords, if they received a security deposit electronically, they must return it electronically unless otherwise agreed to in writing. So upon termination of the tenancy, the landlord must send the notice to the tenant of their right to receive the security electronically if they paid it electronically. So that's an additional notice. And then unless otherwise agreed to in writing, it must be returned to them electronically. However, the law has not changed, and we're talking about Civil Code Section 1950.5. That statute is very long. It's worth a read, but you know, it's good to read right before bed. If you have any trouble sleeping, it will definitely put you to sleep. In that statute, it has always said that when you itemize your tenant security deposit within 21 days of them vacating the property, you have to mail it to them first class mail. That hasn't changed. So even though you may return the security deposit electronically, you cannot email them your itemized statement unless they agree to it in writing. So you can always alter these provisions if your lease provides for it and the tenant agrees to it. When you have multiple tenants and one security deposit, you have to write a check to the tenants with all of their names on it unless they agree otherwise. So if you have multiple adult tenants, who reside in the unit, you may enter into a mutual written agreement with them at the commencement of the tenancy or at any time during the tenancy or even after the tenancy. It has to comply with two requirements. Number one, it has to say how any remaining portion of the security will be returned to them, meaning how, electronically by check or otherwise, including whether it will be returned to one specific adult tenant or divided among multiple tenants with the allocation percentages among the tenants. And then the second element for compliance is for each adult tenant, it has to state whether the landlord will furnish the itemized statement by email or first-class mail, postage prepaid, along with a forwarding address or email account. So if you have a written agreement, it has to comply with those elements. I think a nice freebie for this webinar, I hadn't really thought of it yet, would be kind of an addendum with these elements in a Word version so that you have some of these provisions. And so I'm going to have my assistant remind me that that's what we want to do for the freebie. I'm writing it down because there's lots of new, very minor notices that are required that would be helpful to have in your lease. Also note that special rules apply to victims of domestic violence who have to terminate their tenancy due to the domestic violence. This applies to the victims, not necessarily the aggressor. And a reminder, so 2025, the changes that happened with regard to security deposits were pretty significant. The new rule as of the beginning of the year is that security deposits are capped at 1 month equivalent, 1 month rent equivalent. So the baseline rule is you cannot charge more than the equivalent of 1 month of rent as a security deposit. The exceptions to that rule are you may charge advance payments of rent for up to 6 months. You may form a mutual agreement for the landlord to take a deposit to make structural, decorative, furnishing, or other similar alterations. You may charge 2 months of security if the landlord is a, quote, natural person. That term is defined in the statute. And that natural person owns no more than 2 rental properties. Interesting question that was posed when that law came out is, do those 2 rental properties have to be in California? What if you own multiple rental properties in other states? My interpretation of the law is that it's only counting properties in California. However, the law is very ambiguous on that point. And as far as I know, it hasn't been tested in court. So be very careful if you own more than 2 rental properties anywhere. But I think you'd be okay if it's just 2 in California. So that means that you can charge 2 months rent equivalent as security. And finally, if you are renting to a service member, a military service member, you may only charge 1 month of security. Another new rule in 2025 requires landlords to take photographs prior to move-in and after move-out. Also, post-repair and post-cleaning photos. So you take photos 3 times. Once prior to the move-in, once when they immediately move out to document the condition of the property at those 2 times, and then once after your cleaning and repairs have been made. You have to provide those photos to the tenant if you plan to withhold anything from the tenant's security deposit. I think this is very challenging because you are required to deliver your itemization by mail. So if you don't have a color printer, it can be very difficult to mail photographs. They're heavy. It's going to cost you extra for postage. But this is what the law tells us. And I haven't yet seen a lot of disputes with regard to the providing or failure to provide photographs, but this oftentimes plays out in small claims court, where I don't appear in small claims court because you can't have an attorney in small claims court. So I haven't had a lot of experience arguing these. I haven't had any experience arguing these in small claims court because I don't go there. Okay, the next new law is this disaster law, which provides an additional duty to the landlord in the event of a disaster to remove debris and mitigate hazards promptly, ensuring that the property is safe. So disaster is defined in the statute as a natural or man-made emergency resulting from earthquake, flood, fire, riot, storm, drought, plant or animal infestation or disease, pandemic or epidemic disease outbreak, or other natural or man-made disaster for which a state of emergency has been declared by the President of the United States or the Governor of the state of California. So it has to be a declared disaster. I think really this law was probably set forth after the fires in LA. And the landlord's duty is to bring the property back to habitable condition by removal of debris and mitigation of hazards. And then the landlord is also obligated to notify the tenant in writing once that mitigation has been completed. If the condition of the property is determined by a public official to be safe, that the debris is not toxic, then this law would not apply. So if it's non-toxic waste and you have a determination by a public official, you do not need to comply with this. There's no duty. This does not impose any new duty to rebuild any portion of the property that sustains damage as a result of the disaster. And it does require the landlord to return any advanced rent. I have done prior webinars where I explained that you can alter these obligations based on what's in your lease. So, and I do believe that that rule still applies, even though these duties are now in a statute. They're now stated in a statute. The statutes that were altered are not the ones that in particular allow the landlord to terminate the tenancy based on damage to the property. And in the California Association of Realtors form lease, there is really good language that provides the landlord with an opportunity to terminate the tenancy when some of the property is damaged pursuant to a disaster. And the term disaster is also defined in there. So I encourage all landlords to have a really good provision in your lease that allows you to terminate the tenancy, not based on just what the law says, but that goes beyond just what the law says, that gives you an opportunity to terminate the tenancy in the event of other kinds of damage to the property. That is limited, how far you can go with that. So check in with an attorney if you're drafting your own provisions. But the CAR form, I feel, has really good language in it. The interesting example that I have from recent experience is that what happens if your tenant doesn't want to move out? So we had a situation where the property had been substantially damaged. There was toxic elements in there resulting from the disaster. It did fall under the definition of a disaster, what had happened, and the tenant simply did not want to leave. And the remediation of the toxic elements could not occur. Contractor would not do it with the tenant in place. So we had to go through the process of terminating the tenancy based on substantial remodel, while at the same time dealing with the city issuing civil penalty notice and order to remediate the problems with the property, which I believe were reported to the city by the tenant. And, you know, the tenants also hired a tenant advocate, an attorney, to help them challenge their right to stay in the property. Ultimately, they did move out. We did not have to evict them, but they ran up quite an expensive bill on that because the tenant advocate was going through the motions of doing everything possible to delay the process of taking the case to trial. So it was a very difficult circumstance. So it is what it is. It was a tough one for us. It was a tough one for the client. Was there any way to prevent it? I'm not entirely sure. They had a pretty good lease, and I think that in that case, the tenant just kind of took advantage of the circumstances, which happens. All right, so the next one is related to internet service. So landlords cannot mandate that the tenant use their internet service. The landlord also always has to allow the tenant to opt out of any provided internet services. It doesn't prevent the landlord from having a package of services that they offer to the tenants, but the landlord simply can't force the tenants to use it. And the tenants have the right to deduct the cost of the landlord's internet service if they are not allowed to use their own. So they can deduct it from their rent if the landlord prevents them from using their own. Okay, so then new health and safety standards. This is a new policy that is set forth in the law, but it does not have any specific regulations that we have to comply with as of yet. The rumor was that the state was going to require air conditioning. What they actually did was they declared that they have established the policy of the state of California that all rental dwelling units must be able to maintain a safe maximum indoor temperature. This policy begins January 1st, 2027, and it's a heads up to various state agencies because as they revise their own policies, they have to consider this policy. So the law is intended to apply eventually to residential tenancies of 30 days or more. So it does not apply to short-term rentals. And we will start seeing regulations rolling out from administrative agencies in January 2027. I don't know if there are any statutes in the works that we would have to comply with. Okay, and then the next one has to do with short-term rentals. Tenants, it really has to do with tenants' rights during a state of emergency. But what happens is tenants move into what's, I think, initially determined to be a short-term rental when they're displaced by a disaster. And under the existing rule, once a person stays in a property for more than 30 days, in fact, in my interpretation is 28, but let's use 30 because that's what's in the statute, they receive all of the rights of a regular tenant, even if their initial occupancy was defined as a short-term tenancy or a vacation rental. Once they're there for more than 30 days, if you need to get them out, you have to go through the regular eviction process. So if they're less than 30 days, there's a summary procedure like you would use if you are a hotel owner. It's kind of a quick restraining order type of procedure that can be used to remove the occupant. But once they're there for over 30 days, you have to issue notice to terminate the tenancy and go through the court process. That's quite a bit longer. But if the person is there due to the state of emergency, they maintain the short-term rental rules applying to them for 270 days. What I observe here is that for once we have something that looks like it's beneficial to the landlord, because if the landlord ends up with somebody at their property that they didn't think was going to be there that long, and things go south, they have a little bit more leeway to get that person out quickly instead of getting stuck in court. That law is also set to sunset in 2031. Okay. So then we have lots of tenant protections. There are a few updates for 2026, but I also want to run through some reminders of the 2025 laws again, because they really are still new and I find a lot of people are not in compliance with them yet. or don't know their compliance requirements yet. So the new law in 2026 is a new defense to an eviction. The defense is that if an individual has had an interruption to their Social Security benefits, resulting in the inability to pay rent because, there's a government shutdown, they don't get their check, this is a defense to an eviction. So they have a reasonable amount of time to catch up on the rent before they can be evicted. Then the reminder is that in 2025, we had some expansions of the at-fault and no-fault causes for eviction. They got a little bit clearer on all the guidelines for the landlords, and some of the things that we now have to do, we find that, are a bit particular. So for at-fault evictions, the notices now, and I need to make the point here that we have properties that are exempt from these rules and properties that are not exempt from these rules. I'll talk about compliance in a moment, but if your lease is in compliance, you have notified the tenant whether their tenancy is exempt or not exempt from tenant protection laws. The tenant protection laws impose these just cause requirements that give us a bunch of particulars that we have to comply with in order to terminate the tenancy. The non-exempt properties also have to pay relocation assistance to the tenant under certain circumstances. So this is what I'm talking about right now, is the non-exempt properties. So a non-exempt property, when the tenant has breached their duty to pay rent or breached some other material term of their lease, has to provide a notice to cure the breach and then a notice to quit. So we have to separate the notices. So in non-exempt properties, you can't do a notice to pay or quit. You have to do the notice to pay and wait out the 3 days, not including weekends or holidays. And then you have to do a 3-day notice to quit. The 3 days do not include weekends or holidays on that one either. And just a side note, even for exempt property evictions, we are still doing the notices separately. For our office, unless we're really in a hurry, it's better to separate the notices, in my opinion. There are certain types of at-fault evictions where the tenant is at fault for the eviction, where you don't have to do a notice to cure. That would be if they have committed some substantial nuisance or damage to the property, what we call waste, but there's a higher threshold of evidence that you need to provide to the court in order to meet that burden. So we don't do those a lot because they are harder to win if we have any alternative. And then for the no-fault evictions, these are where the landlord has the reason to terminate the tenancy, and it is not the tenant's fault, it's the landlord's decision. In particular, we have additional compliance issues when the termination is based on the landlord's intent to occupy the property. They have to move in within 90 days and they have to stay there for at least 12 months. There are some other compliance requirements with that one. You also, in many cases, your lease has to say that the landlord may terminate the tenancy if they want to move into the property. The other one that has a lot of new compliance issues is when the landlord has to demolish or substantially remodel the property. So we have to get the permits, or depending on what kind of demolition or substantial remodel it is, if you're removing hazardous waste like mold or asbestos, you don't have to get permits for it, but you do have to provide the tenant with an estimate. And there's special language that needs to go in there. There's relocation assistance, and you also have to make sure that if they want to move back in, you notify them of their right to move back in and let them know that they have to give you their contact information if they want to move back in. So be very careful with those. I recommend getting an attorney if you're going to do that kind of eviction because of all the compliance issues. It also varies between whether you have to comply only with the California Tenant Protection Act, or whether you are subject to some local rules. So using the city of San Diego as an example, it's just one example of many cities that have imposed their own tenant protections. Under the San Diego Municipal Code, those tenant protections go into effect immediately instead of after 12 months. So California Tenant Protection Act goes into effect after the tenant has been there for 12 months. But the city of San Diego is immediate unless that non-exempt tenancy is for 3 months. And then the question is, do you want to do a 3-month lease and just renew it every 3 months? I've seen people try to comply with that. I think that's kind of tricky, but that might be one strategy to avoid some of these restrictions. The city of San Diego also has different requirements for no-fault evictions. The way that you have to comply, the steps you have to take to comply with, for example, an eviction based on a substantial remodel is different under the California Tenant Protection Act versus the city of San Diego. The city of San Diego requires a higher amount of relocation assistance. They require 2 months or 3 months of equivalent of rent for relocation assistance, versus the California Tenant Protection Act only requires 1 month of relocation assistance. The determination of whether in the city of San Diego you have 2 or 3 months of relocation assistance depends on whether you know that the tenant is elderly or disabled. And that presents another host of interesting questions as to how do you determine what their age is and whether they're disabled. How do they know whether you know that? And that comes into play oftentimes with our cases and when we're issuing notices. The city of San Diego has special requirements for buyout agreements, special language you have to use, a disclosure that has to be signed before you can even discuss a buyout, which is the same thing as a move-out agreement or a cash for keys agreement with the tenant, again, for non-exempt properties. Other jurisdictions that have local rules also include the city of Chula Vista, city of Imperial Beach, city of Costa Mesa, city of Los Angeles, and then we're seeing Oceanside considering these kinds of having their own rules, but they haven't done it yet, as far as I know. Some interesting questions have come up with regard to the rent cap, which I'll talk about in a minute, but the city imposed a new trash pickup fee, and landlords who want to include this with the rent have an interesting conundrum. If you are not exempt from the rent cap and you've already been increasing the rent up to that cap, if you want to include the city's trash pickup fee, that amount goes into the rent cap calculation. So if anything that's paid directly to the landlord needs to be included in your calculation of any rent increase. Since that trash pickup fee gets paid through the property taxes, it cannot be paid directly by the tenant. It has to be paid through the landlord. So it has to go into that rent cap limitation. The rent cap is currently 8.8% for the county of San Diego. I'll go back over that in a second. A lot of us have our eye on the, well, that's not the city of San Diego there, huh? Anyway, sorry, wrong city in my photograph, but the city of San Diego is considering a proposed $5,000 tax. If it goes through, it will be on the ballot in June 2026. That's the current schedule. $5,000 per bedroom if you have a property that you're using as a vacation rental or a second home, a vacant second home. This is a significantly troubling issue, especially for those who are maintaining a vacant second home. For example, if you are a person who does not want to go through the horrible process of an eviction, you've been through it before, it was costly and disturbing I totally understand it's not a pleasant experience. So you've decided to maintain this house vacant because, for one reason or another, you're not ready to sell it. This $5,000 per bedroom tax is probably more than you're paying for your property taxes. And it may double or more your annual expenses for that property. So this is hopefully not going to go through, but the city really likes this provision because it's proposed to generate $100 million, up to $135 million in revenue per year. Okay, then let's see, lease compliance. Even though this was really a 2025 issue, I am still seeing about 80 to 90% of the new clients who walk in our doors are giving me leases that are not in compliance with the law. So it is essential that your lease is in compliance. It has nothing to do with whether your tenancy is exempt or not exempt from the law. Every property has to be in compliance by issuing a notice to the tenant of whether the tenancy is exempt or not exempt from the tenant protection laws. So that's the California Tenant Protection Act, as well as we'll just continue to use the city of San Diego, but whatever city you're in, if there's a local rule, you have to have a certain language incorporated into your lease. Now, this for the city of San Diego, that became the law as of January 1st, 2024. And for the California Tenant Protection Act, that was imposed in 2020. So I have distributed the addendum, the city of San Diego addendum many times. I will send it again. I know it's very useful. And okay, so lease compliance. So as I mentioned, California Tenant Protection Act, even if you're exempt, you have to claim the exemption by providing this notice. And it needs to be incorporated into your lease now. Local laws, same thing. You have to provide the notice in order to claim the exemption. In the city of San Diego, you also have to include the San Diego Housing Commission Tenant Guide. That's only for non-exempt properties, but we like to provide it for all properties because it is very informative and there's no reason not to provide it to the tenant, even if your property tenancy is exempt. What happens when someone comes in and their lease is not in compliance? The first thing that we look for is how can we bring the lease into compliance? So hopefully they are on a month-to-month tenancy because the lease term has expired. And so that gives us the opportunity under the Civil Code 827 to issue a 30-day notice of change in terms of tenancy. And that allows us to make the adjustments to the lease. Once the 30 days are up, the provisions that you've given them notice of do become part of the lease. The law interprets those changes as part of the lease. And so that is the way that we bring them into compliance. If they have an unexpired term, meaning that it's a 1-year lease and they haven't reached 1 year yet, we have to wait until the lease term is up. However, we will issue notices right away because, better late than never. Even though they're not effective, it's still better to give the tenants the notices that they were entitled to at the outset of their tenancy. As I mentioned before, the rent cap is 8.8%. That rent cap adjusts every August 1st, and we find out around June or July prior to the adjustment. So from August 1st, 2025 through July 31st, 2026, we're at 8.8%. It adjusts based on the rate of inflation. It's a calculation that looks at the change in the consumer price index for our area from last year into this year. Okay. And then the last one we've talked about before, taking application fees. This was another 2025 update. It requires landlords to not take application fees unless they have a vacant, they know they have a vacant unit. if they do take an application fee, they have to either refund it, or if they don't want to refund the application fees, they have to disclose to every applicant the screening criteria under which they will choose the occupant of the new tenant, and they have to accept the first applicant that meets those criteria. So this involves the process of, number one, having screening criteria, and number two, time stamping your applications as they come in. And that is meant to ensure that there's a fair process. All right. So that's what I have for you today. I'm going to go to the chat and see if we have some questions here. Feel free to post your questions. All right, let's see. First question that we have is, does the law define promptly for disasters? It does not. That the reasonable time is something that often is argued in court if there's a dispute as to what's reasonable. Let me see if there's any further language on that. Let's see. Maybe to remediate. The landlord must comply within a reasonable time after the property sustains damage. If the tenant has provided the landlord with a postal or email address, the landlord shall notify the tenant in writing that the landlord has complied, and that the tenant may view and, if requested, obtain copies of any environmental studies, testing, or reports conducted. It's presumed untenantable until it's repaired. But I don't see anything with regard to specific time frame. The tenant has to have the tenant does have the right to return to the unit, but there's no obligation to rebuild any portion of the property that sustained the damage. If you've taken advance rent, it has to be refunded within 21 days of termination of the tenancy. All right, so there's a lot of language there that would probably require us to interpret this a little bit more. Well, the same question, what does promptly mean? Okay. Yeah, I'm not real sure what promptly means. So next question, you have a property that you manage where the tenant moved in October 2025. Property did not have a refrigerator and was advertised as such. The new tenant purchased a refrigerator when they moved in. They are now asking that the owner reimburse them for the cost of this because of the new law that requires the landlord to provide one. You have an opinion on the request as far as what a fair percentage of reimbursement would be. So what I would propose under the circumstances would be that, the law, that wasn't the law when the tenancy was created. So for the term of that lease, I do not think you would be obligated to comply. However, a compromise would be that the law says if the tenant no longer wants to provide their own refrigerator or stove, they can give 30 days notice, and then the landlord has to provide the appliance at the end of the 30 days. So I think that would be a reasonable compromise and an interpretation of the statute that doesn't argue that you don't have to comply until the end of the lease, although you could argue that, I think, but provides kind of a more moderate approach. Let me see. How does the $5,000 tax impact a senior parent who has moved out of the primary residence? I'm having a little trouble seeing these. How does the $5,000 tax impact a senior parent who has moved out of their primary residence into assisted living and their house is maintained vacant? My understanding, and I think this is under the Revenue and Tax Code, although I'd have to look it up to confirm. But I was advised by another attorney that when a person moves out of their primary residence into assisted living, they maintain their address, their primary residence as their address. So the assisted living does not now become their primary residence. Don't take my word for it. I would definitely want to look that up. But I think that might be an exception, or at least if you had to argue with the city over it, that might be a legal exception to it, because it is not a second home. The law that's proposed has to do with second homes, and so that would not be a second home. Is a family trust treated as a natural person? There's different language depending on whether you look at Chula Vista, City of San Diego, or California definition. But for the most part, the natural person definition applies to a trustee if they have a beneficial ownership interest in the property. So if you're using a private fiduciary as a trustee, I think that there may be an exception there because the private fiduciary isn't necessarily a beneficial owner. They are standing in for the beneficial owners. But you have to look at the specific language to see how it applies from one person or from one circumstance to another. Next question, if you have a rental which is vacant to sell it, is that exempt from the 5,000? It's not the law yet, and I don't think the final version has been established. So I think we have to wait and see. It is an annual tax, and I don't know how the whole compliance issue will work. Do you have to disclose to the city that it's vacant? How do they find out that it's vacant? Short-term rentals are usually pretty obvious because in the city you have to have a license. But when you maintain a vacant home, I just don't know how that gets reported to the city. And if it's vacant for a temporary period of time, we'll have to look at what the city is proposing. So how about if I follow up on that one in a future webinar? We'll definitely be tracking that one. Next question. Which tiers will the proposed short-term rental $5,000 per room tax apply to? I'm just going to have to really look closely at this one because I didn't do enough legwork to answer those specific questions. It's not the law yet, so I didn't pull it up and review it, but I will come back to the next webinar and I'll have more information for you about what's being proposed. How many days of vacancy? So that's the same question. How long does it have to be vacant in order for it to be subject to the tax? So I'll get back to you on that. Are there any exceptions for remodels, demolition, safety issues? And if so, what criteria to determine the exceptions? And keep in mind that it's a second home or a vacation rental. So if you're doing a remodel on your primary residence and it's vacant, but it's your primary residence, I don't believe it would apply. The outline, so the question is, will you get the outline of the 2026 changes? You'll definitely get the PowerPoint. I may be able to update my outline just to give you what you need for those changes because I've got a bunch of other junk in my outline. Next question. If the current lease agreement is not in compliance with current California law, can it be amended midterm? So kind of explain this, but you can change it pursuant to the Civil Code, Section 827, if you're on month to month. So you either have a month-to-month tenancy at the outset, or you had for example, a 1-year lease and 1 year has passed and you didn't renew the lease for another term, so it automatically goes into a month-to-month lease. Once it is on month-to-month, you can issue a notice of change in terms of tenancy. You can also issue a notice of change in terms of tenancy when you're getting close to the end of that lease term to take effect when the lease term ends. So you can issue a 30-day notice of change in terms of tenancy 30 days before the 1-year lease term ends. When you do that in writing, those new terms become a part of your lease. And so that's how we have been handling that issue. If you're in the middle of a 1-year lease and you're 6 months in and you realize you're not in compliance, you cannot, by law, change the material terms of that tenancy. And compliance with these tenant protection laws is material because it has to do with things like relocation assistance and just cause eviction. So it is material. So you can't just change it midterm, but we will still issue the notices to the tenant because it's important to give the notice to the tenant. But you can't make your tenancy that at the outset was not exempt because you didn't claim the exemption by giving the proper notice. Can't change it from non-exempt to exempt until that lease term expires and you do the change in terms of tenancy. So you're still going to be not exempt until you have that opportunity to change the terms of the tenancy to exempt. Hopefully that makes sense. Okay. Next question regarding photos for move-in and move-out. If you don't have photos at move-in, can you use the move-in inspection form, or does everyone who only did move-in forms now have to do a full refund regardless of damage? I mean, that's a great question. I think you do your best under the circumstances. I mean, this law went into effect, I believe, June 2025. So if that tenancy began, meaning not just the tenancy, but like the tenant moved in prior to June 2025, I think that you're exempt from having those move-in photos. If, oops, you forgot to take the photos after that time frame, you do your best. I don't think it's acting in bad faith just because you forgot or didn't know that you were supposed to take photos. So I don't think you'd be subject to the penalty under the Civil Code 1950.5 for bad faith. But you may have to give the deposit back. You still have the right to damages for the repairs that had to be made. So when these cases go to small claims court, if the landlord may have to refund the deposit, I also recommend filing a cross complaint claiming the damage to the property. And so that you may have to give the deposit back, but you may also get a judgment in your favor for the same amount that you withheld. And so it could be a wash in court. Still going here. Let's see. Is there organized opposition to the proposed vacant home tax and short-term rental tax? I believe so. I have been talking to some folks about that, and I need to catch up on that correspondence, but we reached out to the San Diego Association of Realtors to see what they're doing about it, and I believe that it is on their radar. You have the Southern California Rental Housing Association, who I'm sure is on top of this. You've got the California Apartment Association that may have this on their radar. So we'll see. And again, I'll follow up with you guys on this one for the next webinar because I just didn't do enough legwork on it for today. With a compliant lease, what steps do you need to take to have the highest probability that the tenant will vacate on the termination date? The best way to make sure that that tenant gets out when you want them to is to negotiate relocation assistance, because that provides an incentive for them to move out, not only on the date that they provide, but also to leave the property in good condition and to remove all of their things. So that's what I recommend. If you have a non-exempt lease in the city of San Diego, you need to first get the tenant to sign the buyout agreement disclosure, and then you can negotiate a buyout agreement. So you probably want to include that buyout agreement disclosure with your lease and have them sign it as part of your lease. And then when you enter into a buyout agreement, make sure that your form has the language required by the city of San Diego. What's considered good faith effort to mitigate damages when a tenant breaks their lease? That really depends on the facts, and that gets into not only residential but commercial. So, advertising the place for rent is one of the primary arguments that any tenant advocate will use against you if you fail to advertise it for rent. You have to propose fair market rent to the next tenant, so you can't, increase the rent or ask more than is appropriate. You also can't charge less than appropriate and pursue the tenant for the difference unless you really tried to rent it at least for the same amount and weren't able to find another tenant. If the existing tenant is proposing another tenant, you should always look at the proposed substitute tenant, take their application, look at their creditworthiness, and see if they might be a good option. Okay, is that an unfair taking of private property rights, that $5,000 tax? I think that's an argument. An unfair taking probably that argument wouldn't work. I'm not really an expert in that area of law. We're talking eminent domain law, which is constitutional law. A taking has to take the full value of the property in order to be a taking, so it has to leave no other use. Just, not my area of law, so there's a whole lot there. If the property is exempt in the city of San Diego and they have been noticed that the state exemption does, sorry, it's covered up here.
I'm sorry, I don't write well. It's if they've been notified of the state exemption but not the city exemption, until the next renewal, does that cover the city exemption as well?
Not in the city of San Diego. The city of San Diego's language specifically states that if you're not in compliance with the city's law, then any notice issued while you are not in compliance with the city's law is void. And it's very specific that the city's law supersedes the state law because the way that they feel they wrote it encompasses all of the state law. I'm sure you've heard me argue this before. They didn't talk about the rent cap when they wrote the city's law. They just talked about just cause eviction. So you could argue that the Tenant Protection Act is not all encompassed by the city of San Diego law.
So basically, do the renewal as quickly as possible and include the city paperwork as well.
Yeah, or a notice of change in terms of tenancy once that lease is on month to month, going to month to month. And Alan, did you have your hand up? I'm sorry, I was reading all the chat messages and I didn't give you a chance.
Yeah, I wrote a text to Jess, but in the process, if you don't have pictures of the move-in, move-out scenario, I found oftentimes in the pre-move-out inspection and the related documents required, because I provide a settlement charges guide with the lease and in process, basically go over it with them and say, this is the cost. And at that point in time, tenants are oftentimes in agreement with the charges. And you just simply have an agreement as part of the pre-move out inspection report and the charges. Is that valid?
Yes, I mean, it doesn't necessarily get you around what the law requires, but whatever you can do to prevent that tenant from challenging it in court, because really what it comes down to is if you have to go to court, a judge is obligated to uphold the law. If you're not in compliance with the law, then there's a pretty good chance that you'll lose. But if the tenant agreed to the arrangement that you suggest, I mean, get their signature on something, put it in writing, get their signature. That should hold up in court because some of these laws can be waived and some of them cannot. For example, your standard form lease has the notice of their right to a final walkthrough prior to moving out. As long as you have that somewhere in the documentation that they've signed, you're in compliance. Whether they ask for a final walkthrough is really up to them. So I guess, with regard to taking those photographs versus having a written move-in inspection form, you do your best to comply with the law. You've established at the outset of the tenancy what the condition of the property is, and then it's really up to the tenant to do with that information what they will. A lot of them don't know that you have to have those photographs. So it really depends on whether they decide to do something about it, whether they decide to take you to court.
In regard to that, those photographs, the printing of them, having them available, the administrative cost, overhead, cost of ink, the entire effort, in my limited experience, in discussions with the tenant, you have a move-in package, which is the lease and related addendums. You also have to have a move-out package, which is right security deposit rights, right for move-out inspection, standard pre-move-out inspection report and all that. If you do it in writing and state that in lieu of the photographs tenant accepts said settlement charges and expenses, it seems to be a lot more efficient because what they've added is a level of administrative expense to the entire rental process that is onerous.
Yeah, I agree. And I think the question in there is whether you can have them waive the right to the photographs. If the statute doesn't have that language in it, that this is not waivable, then generally you could have them waive it. If you put that in your lease, that tenant waives the right to photographs at the time of move-in, then that's just one more thing that you have in your favor if you do end up in court. What a judge does with that information as far as their interpretation of your lease and what it says and whether they can waive their right to those photographs or not. Sometimes it's anybody's guess what a judge is going to do. We do our best to set up every case to win. And even a slam dunk case has like an 80% chance of winning because you just don't know what a judge is going to do with the information. They'll find other things to hang their hat on that you didn't even see coming. So, we recommend trying to work something out with the tenant as much as possible and get it in writing. That's usually the best plan. I don't know if I guess I may have some more questions here. Oh, in lieu of digital photographs. Sorry, I'm trying to see what I may not have covered before. So it's after 1. I think I have a couple more questions. I'm happy to answer them, but you guys are free to go if your lunch hour is over. What's considered a stove by the new law? Would a small induction cooktop be compliant? So they do define a stove. Hold on. They do have that. Is it in my outline? I didn't put it in my outline, but it is defined in there. Bear with me for a second and I'll find it for you. Okay, I've got it here. A stove that is maintained in good working order and capable of safely generating heat for cooking purposes. Neither the stove nor the refrigerator can be subject to a recall. And if the landlord receives notice of a recall, the landlord has to repair or replace the stove or refrigerator within 30 days. So it just has to be capable of safely generating heat for cooking purposes. Okay. Let's see. If you hold an open house for a rental apartment and applications are all turned in at the same time at the end of the open house and no fee collected at the time, do the applications still need to be time-stamped and explanations for applicants not chosen? So for compliance with the law with regard to application fees, if you're not taking application fees, then you don't need to comply with the law. So you don't need to timestamp and you don't need to disclose your criteria for deciding who gets chosen. However, there is some risk management to consider with regard to your ultimate decision and having a good basis for how you make that decision, because we are seeing a lot of civil rights department claims against landlords for things like not accepting an applicant who had a Section 8 subsidy, not accepting an applicant that had an emotional support animal. Those sorts of things are very popular. We also see a lot of lawsuits relating to failure to accept a Section 8 tenant, whether your reason was something other than the subsidy or not. It's still very popular for tenants to sue. It's not all Section 8 tenants, and most Section 8 tenants are perfectly fine. I don't have any problem with Section 8 subsidies, but there are, it's similar to some of the other kinds of laws where it provides for punitive damages and attorney's fees, and it encourages plaintiffs' attorneys to have like this one plaintiff, and they go around and they apply various places, and when they get rejected, then they just sue based on a presumption that they weren't accepted due to their subsidy. If you timely sent a completed move-in form to the tenant and they did not sign or return, will your form stand? Also, when did the requirement for photos come into effect? Is a video okay? So, I mean, at this point, the form is not compliant if the tenancy went into effect. The tenancy was created after, I believe it's June 1st. I'm so sorry that I don't know that particular date. I believe it was June 1st that this became the law in 2025. And then a video, I believe a video would be okay because a video is a photograph. So as long as it shows the things that were problematic. Okay, I think Alan did get to ask his question. Do you have one more question? You're muted.
Thank you. On the comment of Section 8 and rental applications, I've experienced responses via text and telephone calls, whether I accept Section 8, service animals, on and on. My default answer on all of the above is absolutely yes, yes, yes. Then they ask certain additional sets of information. Do I provide a discount for Section 8? And I said I'd be happy, yes, we'll consider that. And number two, I send them a rental application via via text or email, I find that this oftentimes is not a real Section 8 inquiry. They are fishing to see if landlords are in compliance. I've had a surprising number of those.
Yeah.
Have you experienced this sort of fishing expedition, seeing if landlords are in compliance and giving the wrong answer via telephone and text?
So we've seen many civil rights department complaints. We're handling them on a variety of issues, but that's one of them. We've had at least a couple of those in 2025 and at least a couple involving emotional support animals in 2025. And over the years, many. But yeah, I mean, you don't want to outright reject someone. You want to always consider, and then the risk management suggestion is that you engage in an interactive process with them. Interactive process means you ask them for information, they provide information. When we've defended these claims with the Civil Rights Department, the interactive process was there. It's usually that the landlord asked for more information and the person just concluded that they weren't going to get the apartment because they were being asked for information. Whether that's because they knew that they didn't have that information, or I mean, I don't know. On a case-by-case basis, it's always a unique situation. But we have successfully defended landlords against those claims, and the CRD, if they don't see an obvious claim, then they will usually drop it. And after that, the person who made the claim has the right to file a lawsuit if they want to. Yeah. All right, but it's 1:15 and I've got to go for my next appointment. So thank you all very much for attending today.